I'm Kevin Adams, one of the attorneys here at Mulcahy LLP. Today I want to speak with you briefly about one of the nuances of the California franchise laws, specifically the potential liability of a franchisor's executive officers and directors. As most business people know, entities, usually in the form of LLCs or corporations, are employed to shield officers and directors, along with others, from any damage or harm that may be caused by the conduct of that business. In that instance, a third party seeking to attack the business to get to the pocketbooks of the executive officers and directors will have to pierce the corporate veil to do so. Piercing the corporate veil is a very difficult standard to achieve in litigation. California, however, along with a handful of other states, has codified a section that allows franchisees to attack the pocketbooks directly of the franchisor's officers and directors. Codified at Corporations Code Section 31302, the California Franchise Investment Laws, also known as the CFIL, provides that every person who directly or indirectly controls a franchisor, every partner in a firm so liable, every principal, executive officer, or director of a corporation so liable, every person occupying a similar status or performing similar functions, and every employee of a person so liable who materially aids in the act or transaction constituting the violation will be liable jointly and severally with that of the franchisor. To put this in perspective, a franchisee can sue a franchisor and the officers, directors, and other members of that franchisor for alleged violations of the CFIL. If the franchisee proves his or her case and later recovers a court judgment or arbitration award, then the individual officers and directors will be equally liable with the franchisor to pay off that court judgment or arbitration award. In the event that the franchisor files bankruptcy or is otherwise found to be insolvent, those officers and directors may find themselves alone on an island having to pay back the franchisee. While this statute has been around California for years, those franchisors new to California are often surprised by its harsh results. There are, however, ways to avoid it. Looking back at the language of the code section I had up moments ago, we see that an individual may avoid liability if he or she can show that they had no knowledge of or reasonable grounds to believe in the existence of the facts by reason of which the liability is alleged to exist. Avoiding liability under this section for the individuals of small and mid-sized franchisors may prove much more difficult than those of larger franchisors. In the instance of small and mid-sized franchisors, the officers and directors often find themselves engaged in all aspects of the business. So it would be difficult, if not impossible, for them to show that they had no reason to know of facts that gave rise to liability. The only true way to avoid liability under this section is for franchisors to always take care in selling and disclosing franchise opportunities. To learn more on this topic, please review my article posted on our website. I hope you found this video helpful.